Speaker is entrusted with being the, I would use the word, the principal presiding officer of the House. There is one aspect of the matter, and when he is acting as a quasi-judicial authority, that's a different matter. The 10th schedule has cast that burden and handed over these matters of decision under the 10th schedule in the hands of a speaker. And when the speaker cannot adjudicate, then it doesn't go automatically in the hands of the deputy speaker, it goes in the hands of someone elected by the House. So you see, there is a constitutional setup by which quasi-judicial functions are also entrusted in the hands of the speaker. Now, a speaker cannot remain waiting indefinitely to take a decision, because if the decision is delayed, then there will be no justice for the people who have applied to him seeking the justice. The Maharashtra speaker, unfortunately, was dragging his feet over the disqualification matter, and it is when the Supreme Court was approached, the Supreme Court ensured that there has to be a time-bound delivery and directed the speaker to decide by 31st December of this year. Despite the fact that they were trying to seek time that by February the decision would be taken, but the Supreme Court came down in very clear terms that the decision has to be rendered by 31st of December. Across the country, we know that speakers are generally with a political party. And this is one of the fears which was expressed when arguing the Constitution before the Constitution bench in Kyoto Hall. Always be a biased person when the 10th schedule was under challenge. The Supreme Court in that judgment said, though the speaker may belong to a certain political party, when he sits as a speaker, he dons the hat of a judge. So he has a dual personality. He is a speaker, but he dons the hat of a judge. And it is when he is elected fairly, who cannot say that there is no direction to me. A judgment of the Supreme Court is binding across the country. We already have the Manipur judgment of the Supreme Court, which kept a time frame for taking decisions. Supreme Court now, in this judgment yesterday, in the order passed, has directed it to be decided. One cannot take an analogy by saying that matters in court take a long time. The speaker has one or two cases for a decision. The courts are overburdened with hundreds of cases every day. And it's not possible to compare the speaker's office acting judicially with which is sitting also judicially. Judgment will apply, and this direction will apply equally. And if the Speaker of the Goa Legislative Assembly also thinks he can go into slumber and will not take a decision, and he feels that there is no hurry, I think he will have to have a knock from the Supreme Court in the manner which the Maharashtra Speaker was given, perhaps a harder one, and been told, has to be told in very clear terms, you have to take the decision and not await the term of the Assembly to get over.
बोलचा स्पीकर काहीतरी डिले करत असता तुमका फक्त
बट जाणे काल स्टेटमेंट दिला की आपल्या सुप्रीम कोर्टाची ऑर्डर बाइंडिंग ना. आय थिंक दिस इज नॉट अ गुड स्टेटमेंट ही हॅज मेड, बिकॉज सुप्रीम कोर्टाची जजमेंट इज व्हेरी क्लियर, and Supreme Courtaची judgment he is binding to it, so he cannot do delay tactics. म्हाका दिसता हे 8 गद्दार जे ज्या लोकांनी हांकां निवडून हाडले, ज्या पक्षाचेर निवडून हाडले, तांणी लोकांचो विश्वासघात केल्लो आसा. त्या 8 मतदारसंघान ह्या लोकांनी हांगा निवडून हाडले तांचे आनी विश्वासाचो मर्डर केल्लो आसा. आनी आय थिंक the speaker, in the larger interest of the voters, larger interest of the state, has to decide this case as fast as possible, or else I think Supreme Court will show him his way.
Yes. In fact, it is very unfortunate that the speakers delay. Why they did or time bound this thing from their duty? I was speaker in Goa and I had disqualified Matani Saldana within 3 months, that particular person can always go to higher court if he thinks that the speaker has done injustice. But it is the duty of the speaker to give the judgment on time, because the period of a MLA is for 5 years, it doesn't increase. There have to be elections. You cannot compare this and the other cases which are there in various courts, just prolonging and prolonging. But this is a different case because their term is 5 years. They have to give a judgment. So that if they are disqualified, there is by-election. If they remain, they continue till 5 years. So it is whatever the speaker from Maharashtra is doing is a wrong thing. And also I want to tell the speaker of Goa Assembly that you don't need directive from Supreme Court to take action to give your judgment. Whatever you feel, you please continue and give your judgment. If they agree, they will accept. If they disagree, they will go to higher court.
Amit, what do you like to say about the marina? These days a lot of people are talking, opposing the marina. What do you like to say?
See, Congress Pakshan already we have made our stand clear that we are against this Marina Naushi project. Magasta Goan Sarkaran and
Accused of the matter, then there's no question of going to the High Court and asking them for extension of time. You have to now press for a stay before the Supreme Court. And I have my doubts that the High Court will entertain the application for extension of time. I have also seen in the press that Goa Foundation has filed a contempt petition. So of course the court will see that there is non-compliance with the order, and the court will issue a notice to the authorities concerned and wait their explanation. Prima facie, when you don't comply, there is a contempt. So I feel that the state is walking in the wrong direction in non-complying with the orders of the court. There's one more thing I want to make a mention here in passing. If you look at it, the major violator of environment, the major violators of things which are contrary to law, unfortunately, is the state government. And this is not a very good precedent which is being set across the country. State government should know first to respect the law, and you'll expect people to follow. But if the state government shows scant respect to the law enacted, or you try to change laws to suit your convenience, what will the common man think? He can think that he can buy over and do things. As we see what is coming in the newspapers where the courts are hauling up even individuals who are violating and breaching the law with impunity, whether building in CRZ or otherwise. So this is what I want to respect the law. Because according to us, that land belongs to the state government, and it is MPT which has granted that land on lease, which according to us is a jurisdictional issue and which shall be tested by the court. The government of Goa was before the deputy collector asserting its right to the land, and there are proceedings to this effect. So therefore, the MPT, which is an authority for controlling the jurisdiction of the port, cannot have the authority to lease the land. I will give you one simple example. In certain places we have PDAs. So there is a jurisdiction of the PDA which is encompassed under the Town and Country Planning Act. So if it is zoned as agriculture, agriculture has to be done. If it is zoned as settlement, then you can build residential buildings, commercial and industrial, so on. But it doesn't mean that because it is made settlement, PDA will come in your property and start doing development. Please understand this. So therefore, merely because MPT at that time was controlling the port like PDA, doesn't mean that MPT has jurisdiction to allot land on lease. So this is one of the major grounds of attack in our petition. We also have brought out that there was this marina, Naushi area, as also the other side, which is the Sankwal one. They are having the oyster window pane oysters, which is protected under Schedule 4 of the Wildlife Act. And if it is under Schedule 4, you can't say you do here, but beyond that you do it, because the natural bed will get affected. And therefore, and they will have to have means of access to the land, which means you go over these areas. And the kind of development which they want to do is so massive that it will actually eradicate these window pane oysters and pose a grave threat. Now the government of India has come out after sending out a TOR, terms of reference, to these Kargawal was that agency which was building that marina, Ahoy Marina. So that agency was given terms of reference on which parameters they had to submit for environment clearance. The public hearing was to be done, and if you remember, during COVID, Government of India says under the amended rules that you don't require environmental clearance for this project. We will be examining this on the legal aspect, both if it is removed or not removed, and the impact of it, and whether we need to additionally challenge that amendment or not, or whether we will still require to carry that forward irrespective of the amendment. And we will study that, and that also will be included in the challenge, because we cannot let the environment to be destroyed. And unfortunately, if you see, the BJP seems to be in a tearing hurry to destroy the environment, destroy the Goa, in old Goa project. They notify that as a IPB area. What purpose? Naturally, IPB is for industrial purpose. Heritage area, and the other side you want to destroy it. I've seen that recent notification also relating to the 200 meters line, which then is a regulated zone. Let me make one thing clear. The news came that the government through the town planning department has notified that area and now prohibited it. No, nothing like that. It's a central law on the Ancient Monuments and Archaeological Sites Remains Act 1958. 0 to 100 from the monument is no development zone. 100 to 200 is a restricted zone. What the government has, town planning department has so far done is drawn the line to identify where that line is ending of 100 meters, but not said it is prohibited, etc. You look at the law is a central law. All that is, they identify the land, and they will be restricting the nature of the use, and it has to, and whoever wants to do any development has to apply to the competent authority. That is all. But I am very skeptical about, now see, Marina, how by the back they are trying to get it. IPB for old Goa, and at the same time you are trying to speak of restrictions, and you are still trying to say IPB will come in. I hope you have seen the IPB Act. It tries to say that overrides all the laws. So if it overrides all the laws, then what is the scope of giving this kind of a demarcation under the Building Regulation Act? Because even that law will not apply.